Court does call the case of the People versus Clark.
Alexander, on behalf of the people, Your Honor.
Shane Clark.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Clark, who is now approaching the podium.
Those emergency motion. Go ahead. You may proceed.
Thank you, Your Honor. The people filed this motion. I believe the defendant was arraigned on May 1st and was given a personal cognizance bond. And this was against the request for a $25,000 cash surety with a GPS tether. People have serious concerns in this case for particularly the victim's safety, with nothing more than a PR bond in place. In this case, the victim's defendant argument, he called her a fat bitch and pulled out a knife. He was held the knife to her throat while yelling in her face, "If you interrupt me again, I'll snuff you and kill you right here." He was so close to her face while he was yelling this that spit was hitting her face. He said right before he left the car, he stated to her that once he gets his disability check, he's going to buy a .22 caliber gun and shoot her in the head. She's in fear for her life and her mother's. She also received a text, which I believe, and for it to be read into its entirety, and it says, "You better for real stay out of my way. Don't text me unless I text you. You take my child's phone away again, I'll dismember your whole body to pieces. No cap. I'm overplaying with you. I will literally just kill you and get my life right. Free healthcare. My daughter's safe with your mom. Keep fucking playing. CUNT. I promise you don't know how real I am." And I have just extreme concerns given that he held a knife to her throat and is threatening on multiple occasions in this one case to kill her. And after the arraignment, the victim did send us a screenshot of a text, I believe from March 28th, which was before this case occurred, from the defendant, in which the message said, "Call the cops. I don't give a fuck. I'll murder your ass the day I get out." And that was before this case. So I have concerns given that she has finally reached out to police about this defendant's behavior. What could happen to her given that he's out on a PR bond for this, in which he threatened her life twice. Oh, probably more than twice, I believe. 3 times.
Response.
Your Honor, I'll be requesting that the court maintain the PR bond with GPS tether. Mr. Clark is currently on a GPS tether. It was addressed that day that one issue, as noted in the prosecution's bond motion, was a concern about a cell phone. Mr. Clark does have a cell phone, which he is using now for his GPS tether that's currently on his ankle. The concern was a lack of data, not him not having that device. He now has data on that cell phone. He received that. He had until Monday today, the 5th, to obtain that tether device. However, he did so within 24 hours. He was released from jail on May 1st, 2025 at 3:57 p.m. I received a call from Mr. Washington, one of the tether agents from Community Corrections at 1:22. So within that small time frame, he was able to obtain data for his cell phone and go to Community Corrections to get a tether. Mr. Clark has also been in contact with social workers, one of whom drove him here today, who are assisting him greatly in obtaining housing, which he is now on a list for those who are chronically unhoused, and hopefully should be able to obtain housing soon, and to be put on a second list as housing vouchers are now being opened again. They've also been assisting him with other matters, such as his health. He is currently suffering from liver failure and has an appointment scheduled for May 9th and one for June 14th, which at that time, his social worker will be also assisting him in getting a hotel. As noted in the emergency bond order by the prosecution, Mr. Clark has successfully been dismissed from probation in the past, showing that he can follow court orders. He does have the money to pay for the tether. He does have transport for the court. And the complaining witness, while acknowledging that this is a serious case, does reside over 30 minutes away by driving. Mr. Clark does currently rely on his social worker for transportation. Again, those, as mentioned, anything mentioned by the prosecution, it's still allegations at this point. We are not here to litigate any of the allegations here today. We are here to address bond. I do not believe there is any change in circumstances that have occurred since his arraignment that I handled last week that would warrant any changing of his bond. He is currently on a GPS tether. The court can know where he is at all times. And I believe that this bond is sufficient to protect community safety.
Is the GPS just location tracking?
It's location tracking and includes an exclusion zone for the complaining witness's address. So he would not be able to get within a quarter mile of that address.
Where's the defendant residing at this point?
He is currently residing at a camp as he awaits housing.
At a camp?
Yes, he has a campsite that he resides at.
Where's the campsite?
It's by the park and ride, sir.
Well, just so that we're clear, this isn't by the parking ride?
Yes, sir.
So this isn't a commercial campsite. This is just a place that you have.
But I'm holding out until I can get help, sir.
Yes, which he is part of the Pathway Housing Program. I do have a letter from that social worker here if you'd like that, Your Honor. And Ms. Montaigne, the coordinator for that program, is in the courtroom at this time.
Pardon?
Ms. Montaigne, the coordinator for that program, is also in the courtroom. She is the one who helped Mr. Clark get arrived at the court today.
The The only address I have is a South Line address. Is that a correct
I
statement?
believe so, Your Honor.
How do the defendant and the alleged victim in this case, how do they know each other?
Your Honor, I believe they have been in an on and off relationship since January of 2018, and they have one child together, and that his previous DV from 2021 was with this same victim.
The child resides with mom. Is that
With her mother,
Her mother.
the victim's mother.
It's the magistrate did order no contact with the victim's mother as well on the day of the arraignment.
I see that, but so does the victim reside with the mother also?
I believe so, because it says the child attends school in South Line as well, so I believe so.
How old's the child?
Born in 2019.
Oh, 6. 6. The defendant's not working.
The defendant is working on getting a disability at this time due to some of his medical concerns.
Then how is he paying for the tether?
He does have some, he has shared with me, he does have some money for the tether.
Panhandle and pick up cans and do work for a lady that I know whenever she needs it. She hires me for yard work.
So how long have you been residing at the campsite that you set up?
Since last year, sir.
Are you the only one out there at that site?
Yes, sir.
Let me see, counsel in chambers, court standing. All right.
All right, might as well be a good time for me to go ahead and hit pause and just say hi to everybody. Trying to figure out my camera. Not sure I'm going to have a video camera up tonight, but I've got the ear pods going, so maybe we can do that. Thank you for everyone coming out today. Didn't see a lot of y'all in Judge Fleischer's stream today, but guess all of y'all know that Judge Fleischer's not streaming anymore. That was a choice that was made in his courtroom, not made by us, not made by anything we did. You all could be proud of how y'all behaved in his chat. I wish I had more information to give, but I don't have any more information. But I will tell you that on Monday morning, Judge Fleischer will not be streaming. We're looking at who we should have on. Make sure to put in the comments if you think a certain judge would be great. Every option is available. No one is sacred. We're going to throw them up there and see what works and see what the community likes. So we're going to jump back in this one. This one again was stolen from Courtroom Cat. I've got 3 of them stolen from him today. I didn't have time to go looking, so we did some stealing.
Back in the record on the Clark matter. I've had an opportunity to speak with counsel in chambers, and what the court is going to do at this time, and Mr. Clark, I need you to understand what I'm going to do. I'm going to leave you on the GPS tether. I'm not going to increase any monetary bond that might incarcerate you. Okay, you understand that, sir?
Sure.
And then what I'm going to do is I'm going to, at this moment, increase the exclusion zone on your tether for all of South Lyon. Okay.
I understand.
And then, and I don't want it put on the record, but I'm also going to add a provision of no contact with the minor child. You understand that, sir?
Yes, sir.
All right. And then once the other part to this is that may change where I get more information regarding the victim, the alleged victim, and her travels. And then I may be expanding that exclusion zone. Follow me?
Yes, sir.
All right. So that's what I'll do at this time. I think I'm going to need a new order. So I'll prepare a community corrections order with the exclusion zone is all of South Lyon. And then Ms. Zenda, if you could provide to the clerks the name, the minor child's name, and then we will be adding that to the no contact. So at this time, I guess theoretically the motion is granted. The exclusion zone will be extended to all of South Lyon, and I will add the child's name there. Anything further?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor.
All right. Thank you. Thank you, sir.
That's a heck of a comment. 9-6, your
All right, jumping into Judge McNally. This is another video stolen from the Courtroom Cat. So, I see that comment, Fozzie. I'm gonna put a comment up there just for you, Fozzie. Man, I wish I could stream more often, but I got to pay the bills, and this ain't paying the bills. But maybe if I stream more, that would pay the bills. I don't know. It's kind of a double-edged sword. We're just gonna do what we can. Let's jump into Judge McNally. I haven't seen this one, but I can assume it's good. 1, because it's from Judge McNally, but 2, Courtroom Cat took care of us. So make sure to thank Courtroom Cat. Go check out his channel, watch all his videos, all that other stuff.
name again? Guest. Or Mr. Street, rather.
Yes, sir. Can you hear me good now?
Yeah, now state your name.
Michael Street?
Ma'am,
Santana Carneiro.
do you have everything you need?
I did not receive Jennifer's email. I don't know if it's back. I don't know what happened.
Jennifer,
but,
did you email everything over there?
Yes, Your Honor, I sent it to the,
I have your last email here, Jennifer. I can answer to that.
yeah, I sent it at 11:44.
What did you send, Jennifer?
Copy of the
my-
text.
We got it.
Refresh. You got it?
The same things that we got last time. Her social security is blocked.
Well, I have a problem with the social security. I mean, I can do that later. I can worry about that later. Do you have everything else?
There is no social security card.
She doesn't have it, she said. She told him down there. What else?
She did not send the latest tax return, only the 2023, not the 2024.
Do you have the 24?
2024
Hang
was in
on.
that scan, Judge.
24 tax return was in the scan, right?
Yes, Your Honor.
Okay, so you're gonna have that. You gotta pay this. Okay? Where do you work now? She can garnish your wages. They can garnish your wages. Which is where?
Where the corporate is based out of Arizona. I have 3 locations that I go to between Dundee, Ann Arbor, and Livonia.
You're gonna give me all those addresses right now. You got them all?
Yeah, I gave it to you last time. I know by her. And the time before then.
You gave them to me?
First, second, and this.
The addresses?
Absolutely. And I gave it to them on the record as well.
Is that right? Do you have her addresses for where she works at?
We have the address on the earnings statement, which is in Tampa, Arizona.
Did I give you the, hang on. Did you specifically spell out the addresses? Hang on. For the 3 locations you're referencing.
Yes, Your Honor.
You know them by heart?
Yes.
Good. Give me them again. Okay.
The first one is going to be,
You have the phone numbers?
yes, I can get them for you.
Why are you not paying this debt at all?
I have, Your Honor, I was on medical from October until middle of January. My first check was February. I nearly died. I've had to have 3 blood transfusions, and I'm going through a hysterectomy as soon as I can afford to take time off work again.
Okay. I'm sorry about all that.
Yes.
Why don't you give me an amount you can pay? How much do you make an hour?
Long salary.
How much do you make per week?
Right now I went exempt, so I get paid bi-weekly, and I bring home 24.20.
I don't want to know that. What's your yearly salary?
71,
71,000?
yes.
Why aren't you paying on the debt?
If you look at my last year tax return, this current year tax return, I only brought home 44 this year. I just started that job.
Do you have kids?
I do.
Any that are not adults?
Yes, I have 2 at home.
How old?
17 and 14.
Do you collect child support? How much can you pay per week or bi-weekly?
I mean, I'm check to check, whatever
I-
you tell me I have to pay, I have to pay. I mean, I literally have I just got paid last week and I have 85 cents in my bank account. I'm trying to play catch up from everything. I've lost my daughter. I've lost my home.
Has no bank account before. She's just a compulsive liar. We are so frustrated, seriously.
Okay, let's stop. I don't want people calling people names.
It's so frustrating.
Never had a bank account till
It's
just now.
probation officer, Ms. Wiles, keeps calling me, telling me that these people are calling routinely, like weekly.
All right, I don't want anybody casting aspersions. You owe them money.
Of course I do.
And you made it very difficult. I've never seen anybody here, just so you know, in 30 years and 4 months, I've never seen anybody here on creditor's exam on civil cases more than you. Imagine that.
It's the same
Hang on.
case.
Yeah, I know, because you didn't provide the information you were supposed to provide. No, you didn't. It took me multiple attempts.
Your Honor.
Ma'am? The debt is 5374. How much has she paid on this? Anything?
$150. She made 2 payments. She was in a payment. You asked her how much she could pay, and she was in a payment of $75 a month. She paid 2
No.
months and
Jennifer, pull out an order for installment payments for me. I want you to prepare one.
Okay.
If you do this, if I set an installment payment order, they cannot garnish wages. I want to be clear about that. If I do that, you guys cannot garnish wages so long as she's staying in accordance with the payment plan. And if she isn't staying in accordance with the payment plan, you're going to have to file a motion to set aside the installment payment order. Then you, hang on, then you can garnish. So I'm going to set up a new one. She's going to pay on this. And it's that, ma'am, I just want you to understand one thing. I could get $1 million judgment. You can get $1 million judgment against somebody and never collect a single cent. I just want you to know that. I'm not trying to be a wise guy here. I'm not boasting about this. I'm sensitive to what you're going through, but I want you to understand. Sometimes people are not collectible, okay? There's millions of them in this country. I'm trying to get you your money. I can't lock her up for not doing something unless she ignores orders of the court, and I'm going to set a reasonable amount. You're making $71,000. Talk to me about the rest of you. Jennifer, you're going to start to pay an installment or prepare an installment payment order, please.
I'm typing now, yeah, Judge.
Thank you. Now, I want you to tell me what your bills are. Where do you live?
I live in Boston.
Okay, where?
Mayfair Avenue.
How much in an apartment?
No.
You own the home?
No.
You rent the home?
I rent the home.
How much is it?
$14.50.
What else? What other bills?
My DTE is $476 right now.
Well, you're not paying $476 a month.
It's like $380.
I know, but this, okay.
I'm on a shut-off protection plan. That's my payment amount, $476.
Okay, what else do you have?
My cable in my home.
How much do you pay for cable?
$226.
Wow, that's a lot.
It's my home, my cable, my internet, and my
What else?
home security system. My cable.
Do you have any car payments?
Yes, $400 a month.
I thought didn't you say you?
It was repoed and I got it back. So now it's
All right.
$200 bi-weekly that they agreed to give me the vehicle back.
Okay,
My cell phones,
how much?
$200.
Okay,
I actually just got it reduced to $280 monthly for the same case with them, with the criminal side of it, that I have to pay for probation fees, and it's $280. Yeah, $280.
Your Honor.
what do you want to say? I'm not going to order people not to pay something I know they can't afford. That's poor judging. I don't want to do that, okay? Tell me what you want to say.
She has a criminal case against her, and she's not even making payments on that. The probation is supposed to be over in August.
Is that,
and that's
hang on,
I emailed.
hang on. Is that in front of me or Judge Heston?
Yes. And it's up to date.
Ma'am, listen to me. I hope you listened to the first part that I just stated.
Yes.
I cannot, in good conscience, order people to pay things that they cannot, an amount that they cannot pay. It serves no purpose. Serves none. I've heard enough. I'm going to go ahead and order you. You get paid when next?
The 17th,
Of May.
yes. Which is next Friday.
Jennifer, you're going to prepare an order that's going to say The defendants to pay $85 bi-weekly commencing May 19th and every other Monday until paid in full. Folks, that's the best I can do. If she doesn't make a payment, and you have to send it to them. Did you hear me?
Okay, because I was bringing them here and they were sending them.
Is that right? We were doing that, Jen?
Judge, because she was indicating there's no contact order, I was allowing her to bring the money order made
Oh,
payable to them, and then I mail
Well,
them.
we're gonna allow you to do that, and we'll send the checks to you, but they have to be here in these days.
Your Honor, can I ask for something? So I have to pay the $280 on the 9th, which I have to sign in to see Judge Hessen to see if I can get it on my pay period because I had a.
Whatever. What is your question? I'm not. Go ahead. What's your question?
Can we move it out?
Move out and go talk to Judge Hessen, tell her what I did. And then you can talk to her about paying your others later there. But I think this has gone on too long. Okay? So no, you're gonna have to pay this on the 19th. You got something with Judge Hessen? You go talk to Judge Hessen, okay? I don't have any business dealing with her files, okay? Good luck. 85, I expect you to pay it. If not, you guys file a motion for to set aside the installment payment order. Listen to me. Then they're going to be garnishing wages. And if you think you got financial problems by paying $85 bi-weekly, wait till you see what kind of problems you're gonna have when they start doing that. You fully understand me?
Yes, I'm losing everything right now because of this whole case. Yes.
That's a heck of a comment to make.
Run on check to check.
Ma'am?
I didn't ask to be sick and have a blood transfusion.
Well, I didn't want you to have that either, but
For 6 months.
but you owe them money. Had you conducted yourself as you were supposed to, you wouldn't owe them money.
Can I ask you a question?
No. I don't want to get agitated when people ask me questions like that or make statements like that. It'd be like if I didn't pay my credit card company and they started coming after me. And then I stood before a judge and said, boy, this is ruining my life. Maybe, just maybe, I should have thought about not spending so much when I was building up a $30,000 credit card bill. I have nothing more to say on this. I've been more than fair with you. I'm sorry you're going through health problems, but you have to bear some responsibility here. And honestly, this isn't a criminal case, so I don't really care, other than the fact that these people deserve to get their money. You make a lot of excuses and rationalizations. That's all I'm going to tell you. This has been ridiculous how many times you've been here on this. I don't want to say another word about it. If you have a legitimate question besides asking me to do something else, I don't know what to tell you. What is your other question?
I'm not trying to avoid this. I've had people counsel me and tell me, listen, you need to file bankruptcy.
Well, do it then. I don't have any.
But I'm trying to give them.
Ma'am, you gave them $150 in 1 year. Now, did you pay him $150 a month since I ordered the judgment?
From September, that judgment was ordered in September.
Okay.
And I paid in October, all the way through October.
And you haven't paid November, December, January, February, March, or April. Okay, so if you pay $150 every 6 months, just if you want to quarrel about this, if you got a judgment for over $5,300, that means at that rate it would take 18 years. Now, please don't argue with me. I don't want to hear it anymore. This has been a painful experience on something that should have not taken more than 5 minutes. That's it. Good luck. Thank you.
You still hear it?
All right, I guess we're at the end of that one. I haven't noticed that Critter's got a new profile picture yet, so maybe whenever I see it, I'll make a comment about it and tell her how great it is. But I haven't seen it yet. But if you guys see Critter has a new profile picture, say hi to her and tell her how pretty it is. Let's see what other judge we got. Let's see where we're gonna go. All right. Have we done the? Well, I'm having a long night tonight. let's drop. Let's check. Have we done Judge Webster? I don't think we've done Judge Webster. Have we done? Let me know if we've done Judge Webster already.
Ma'am, that was during a time of intense.
Y'all let me know. Have we done Judge Webster yet? I don't think we have. Let's just go ahead and go with it. If I've already done this one, y'all let me know.
Appreciate it. Thank you. To have him confirm the serial number and such.
Yes.
All right, we are on the record in 2024 TR 1761, State of Kansas versus Amanda Jean Lockhart. Jared Regier for the state. Amanda Lockhart appears in person and pro se. You are Amanda Lockhart.
Yes, Your Honor. Thank you for taking the time to hear my case today.
You are welcome. You told me way back on September 18th of 2024 that you are going to apply for diversion on this registration tag violation. September 18th of 24, it's now May 7th of 2025, and I don't see you did apply. Did you?
Ma'am, let me just say I'm very, very confused as to the situation. I think that I've missed some kind of step in here. I was unaware that I had done something to have a warrant. I got a letter saying my license was going to be suspended. But may I say one just quick thing to explain where my confusion is so that I can make sure I'm on the same page?
Let me help you first.
Okay.
Okay. You were on July 3rd of 2024 stopped for not having a valid tag or legal registration.
Yes, ma'am.
July 3rd of 24. You were given a citation for that offense. You were to be here July 18th of 2024 to answer for that charge.
That's where I got missed, ma'am. I did not know I was supposed to come in. I
No.
apologize.
No, you were here.
Via Zoom?
You appeared July 18th, 2024 before me with County Attorney Jared Regier. You were present by Zoom.
Yes.
You told me, I read you your rights, your charges, your possible penalties, and you said you would like to look into diversion.
Yes. Yes,
So
ma'am.
that was September 18th. September to October, November, December, January 8th was given as your next court date. That gave you some 3 to 4 months to look into diversion for this one count of tag or registration.
Yes, ma'am.
I personally gave you that date. January 8th, the date you were told.
Just to mention everything, I've been watching Jared Regier in the corner there. I don't think he's moved his neck. I've seen him rotate his head, and I've seen his eyes move, but I don't think he's actually moved from that position. If somebody sees his shoulders move, let me know.
To be diverted or be in court, you were not diverted and you were not in court.
I apologize.
Therefore, I issued a bench warrant and I set the bond at $500 cash or surety.
I think that's, I'm sorry.
We are now January to February, March, April, May, another 4 months. Still no diversion. You are here. How are you wanting to proceed on this charge? Are you going to plead not guilty and set it for trial? Or are you going to enter a plea of guilty or no contest and proceed to sentencing today?
I don't know, ma'am. May I just ask a question just for a moment?
Go ahead.
I apologize for holding up proceedings too. I honestly did not mean for any of this to happen, and I apologize profusely. When we ended our Zoom meeting, I called the number that you gave me. You said to call a number to finish doing things. I left a message 3 different times. I didn't hear anything back from anyone. I called a couple more times. I kept being told that I was in the wrong department and given different numbers. I kept leaving messages. I apologize. This wasn't intentional. I will do whatever I need to do to make it right. I would love to apply for diversion. I didn't mean to not apply. I feel like I was very confused as to what I was supposed to do, and I apologize. What are my options here, ma'am? I don't know what to do.
Well, the options are what I gave you in September, and that we've discussed every other hearing, including today. You've had about 8 months since you saw me to apply for diversion, and you haven't.
I didn't know I was supposed to. I really honestly was confused as to what I was supposed to do next. It was not intentional.
Well,
I will happily do.
I'm not going to continue this again for diversion. You've had
But
plenty
I
of
didn't know I
time.
was supposed to, ma'am. Honest to God, I didn't know I was supposed
It wasn't
to.
that you were supposed to. You said you wanted to, and
I
gave you the
did.
opportunity.
I did,
And you
ma'am.
usually do that by following up with a
I've never been in
web
trouble,
address rather
ma'am.
than telephone calls. I need to
But
know today how you want to plead on the charge, the unclassified misdemeanor charge of driving without registration or tag on July 3rd of 2024. Once again, your options. You can plead not guilty and we can set this for trial. And the state will have to present evidence to see if they can prove that you were driving in Butler County on July 3rd, 2024, without a tag or registration. You have the right to present evidence if you want at that trial, but they can't make you, and you're not presenting evidence won't be used as guilt. The burden will be on the state to see if they can prove that you did not have a tag and were driving that day. Option 1, not guilty and set it for trial. Option 2, plead guilty, admitting that you drove without a tag, and proceed with sentencing. Option 3, plead no contest. That means you're not admitting you did it, but you're not denying it. You don't want to go to trial. You're basically standing mute, and you will still be most likely found guilty and proceed with sentencing.
No, I was driving without valid tags. Absolutely. I plead guilty to that charge. As I showed you at our
Before you go any
previous,
further, there is a penalty possibility of 30 days to 6 months, which is, I don't know that I've ever seen it imposed. The probation's an option. But because the sentence could be up to 6 months, even though I've never seen it, you can hire an attorney. You want to talk to an attorney. If you can't afford an attorney, you can apply and see if you qualify for court appointed. That may include an extra fee, but it's much reduced from what you'd pay outright. It is
ma'am,
based on your ability, if any, to pay. So do you want to hire an attorney, apply for court appointed, or waive your right and proceed with your plea today?
I honestly, ma'am, I don't know. I didn't mean for any of this to happen.
Well, you don't
This was a
understand.
mistake, I promise.
I'm not looking at your intent so much as did you do it?
But
Because you have a duty, but let's hold up. Let's hold up.
I'm so sorry, ma'am. I've never been in
You're
trouble.
fine.
I didn't know the
You're
proper
fine.
proceedings.
I just first need to know, are you going to have an attorney?
If I need one, I will get one, ma'am. I've never had to have an attorney.
You're the only person that knows whether you need one or not. I can't make that call for you, Miss Lockhart.
Well, I know, ma'am, I know that I was driving with expired tags at the original time of the ticket, but I
Okay.
did immediately get those tags taken care of as I showed you at our first Zoom meeting. So I did follow up. I fixed the tags. I had valid registration ever since. I wanted to apply for the diversion, but I didn't understand what processes I needed to take or what to do. Again, I apologize. I don't know what to do because I'm sorry.
Well,
Okay,
Miss
I'm waiting for a tissue, please.
Lockhart, this does not appear to be the first time you've been to traffic court. You had a case in 2017, operating a motor vehicle without a license.
That was actually, no, no, no. May I please explain that? I did
No,
have a
just-
license. It was a Washington license and it was still valid. That was
All right, so you went to
dismissed.
court. Well, it looks like you went to court for that.
I did, but it was a mistake from the officer, ma'am. He thought that since I
Okay, in
had
any event, you went to court. In 2019, operating a vehicle without liability insurance. So you had that experience.
ma'am, that was during a time of intense poverty. Both of my parents had just committed suicide
Okay,
and
but-
I had just taken over care of my grandmother. I had inherited a huge amount of debt from my mother. I was
I don't
just
want to
trying
get
to.
into those. I only bring them up because what I perceive is that you're trying to tell me you've never been through anything like this, and so you don't know
Well,
what to do.
not to this level, ma'am. I've never missed a date. I've never not followed through, I guess is my point. I didn't
Well,
mean to miss a
the
step because I'm sorry.
missing the court date, that's behind us now. You're here. We need to move forward. You've had, since the ticket was issued in July of 24 to go for diversion. I'm not going to give you more time. You've had 3 court
Please.
dates.
Please
I'm not gonna
allow me
give
to make this right. Please, Your Honor,
I
please.
am not going to continue this again for diversion.
Uh,
You can either
Please.
hire an attorney, apply for court appointed, or represent yourself.
Ma'am, I will go right now and do it. I honestly did not.
What?
I didn't not do it on purpose. I wanted to apply. I was trying to contact people to
Just
find out
need
what to
know,
do.
ma'am, if you're going to have an attorney.
Don't know. I don't know what to do. I don't know. I don't know. I'm so sorry. I don't know what to
I'm
do.
going to set this for trial.
I don't.
I'm going to set this for trial. What was the date again?
I don't want to go to
July 9th,
trial.
Your
I know,
Honor.
ma'am. I know that
July
I was
9th
guilty
at
of trying to.
1:30. Okay, Miss Lockhart, calm down if you can and listen. Try to be calm so you can hear what I'm saying. I'm setting this for trial July 9th at 1:30 to determine if there's evidence to convict you or not of driving without a tag. In the meantime, you can go to the county attorney and see if they would consider diversion. It's their diversion program. I will not continue it again to allow you time to do that, but I recognize that you'll be free to go down and try to get it if you can. But if you do, it's going to have to be applied for, signed, and filed by July 9th when I call your case for trial. Likewise, if you want an attorney, that'll give you time to go hire an attorney. If you cannot afford an attorney, that'll give you time to apply for court appointed. But if you do nothing like you have for the last 2 court hearings and all this time that's passed, then we're going to trial with or without your attorney. Because I've given you plenty of opportunities and plenty of time, and it's not your first traffic case. It may be the first case you've had where you failed to appear, but it's not your first traffic case. And that failure to appear is not going to have bearing on whether you're found guilty or not guilty July 9th at 1:30. It's not going to have bearing that I know of on whether or not you're granted diversion. Maybe the county attorney will consider failures to appear, but that's between you and them. I will continue the $500 professional surety bond with the conditions existing on it and the added conditions that you reappear July 9th at 1:30.
Thank you. I want to make this right. Thank you.
You're welcome. Anything further, Mr. Regier?
No, Your Honor.
All right, the defendant, Ms. Lockhart, is released on bond at this time.
Thank you.
Welcome.
Judge, you want to take Mr. Woods' case back up?
Yes,
Officer went out and checked this window.
you have the officer there.
Yeah.
All right, that's the end of that one. What fun was that? All over a dang driving violation. Does anyone remember what the driving violation was? I don't remember. Let's see. I had one just a minute ago. I'll find it. One last one and we'll be out of here today. So let me find it. Here we go. Judge West in Texas.
Good morning. You're Christopher Bushnell? So, Mr. Bushnell, you were previously in court, entered pleas of guilty to the third-degree felony offense of evading arrest or detention with the use of a vehicle, and the second-degree felony offense of engaging in organized criminal activity. Those were for agreements of a 10-year probation deferred in each of those cases. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Are there any additions or corrections to the report?
Just that it may indicate that he doesn't take full responsibility, but after speaking with him, he does take full responsibility for his actions and involvement in both cases.
I've also reviewed jail incident reports. Have you both been given a copy of those?
Yes, Your Honor. I have.
So you're 17 now?
Yes, ma'am.
December 26th.
And Judge, if we need to go back and renegotiate an offer, obviously he's not even out of custody yet, and this is how he's acting.
Well, and
Your Honor, obviously due to his age, I want him to have the opportunity to get his life together, obviously not going into adulthood with felony convictions. I have preached to him the importance of following the rules and not...
And you can't do it, can you?
Okay.
You cannot. 21 incident reports since January 25th of this year. 21. Fighting, calling officers names, stealing food, instigating fights, being a bully to other people in the dorm. Ridiculous. So if you can't follow rules in the jail, what makes you think you're going to come in here and I'm going to say, sure, go be on probation out in our community? After y'all shotgun, I mean, this is serious. I'm tired of the shootings. I'm tired of people. You could have killed somebody. And because you accidentally didn't kill somebody, you get to get a probation. Not today. If I could send you to ISF, I would consider it. I can't. At this point, I'm going to reject the plea agreements. We will set the cases for a review in about 30 days. Let's see where we are, go over his options, y'all talk. If I can always do, upfront time, but we've got to get to a certain point where that would make sense. And so at this time, I'm just going to reset the cases. Again, I'm rejecting these plea agreements. And let me tell you, you get more of these, it's only going to get worse. I'm going to see them. A jury's probably going to see them a jury will see them if you go to trial. And you're going to end up in prison for up to 20 years because you can't follow the rules in our jail and you're acting like a little punk. So go stop acting like a punk, prove that you can behave, then we'll see what happens. When you come back next, I'll see how many of these I have. Go back with the bailiff. Mr. Kimler? Yeah, on Mario Blunt. That's a sentencing.
Judge, I've spoken with the probation officer who's here, and I'm just going to ask the court to follow her recommendation. The one allegation that would have been proved up is a misdemeanor assault from last year that was never filed by the police department.
Okay.
It looks like we don't need to proceed on that.
So it looks like the recommendation is substance abuse.
ISF.
Or substance abuse also.
Well, it actually says substance abuse cognitive, and we can't do both. So
Is there one more than the other that understanding that the problems are both cognitive
Yes.
and drug related. In your opinion, what do you think is best?
Cognitive first with JCBI after.
okay, that would make sense.
And so that would be our, I understand this isn't an agreement, I don't think, but this is what we're asking the court to do based on the pleas that have been entered in probation's report.
I guess you're on the record.
Mm-hmm.
In talking with Mr. Blunt, I think that he will do, obviously he's not going to refuse ISF. He was going to suggest that he's using or has used marijuana or THC in the past to cope with anxiety issues in lieu of ISF to perhaps try to pursue something through MHMR.
Well, he didn't just use THC. He also used methamphetamine, and I'm pretty sure that's not very good for anxiety.
Well, he's not contesting ISF.
Yeah. So, Mr. Blunt, you're on probation for an extremely serious offense. I could be sending you to prison today for a very long time for violating your probation. Sounds like probation's willing to work with you. You've done some positive things while you're on probation, which are good, that you are going to treatment. You've made a great deal of progress. Those are the things that I'm really concerned about, but they're not the only things I'm concerned about. You've got to follow all of the rules, not just some of them. You've got to get this drug deal kicked. If you don't, you're going to go to prison over drugs instead of really what you or the underlying offense is. Do you understand?
Yes.
We're going to give you the opportunity. We're going to give you treatment. You take advantage of it and change that part of your life. Great. If you don't, you're back in here, and this is going to be zero tolerance. There's no messing up at this point.
Yes.
Do you understand?
Yes.
If the treatment that you're getting through JCDI is not enough, it's going to be up to you to be a grown-up and go to probation and say, I'm feeling tempted. I need more help. Nobody wants to go into custody for more help, but it's better to go in for 90 days than it is to go to prison for up to 20 years. Right? Okay. So in clause number 15-21380, I'm going to find that you entered your pleas of true to counts 2 and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to follow the recommendation of the district attorney in probation and continue you on probation in order that you enter and successfully complete the cognitive track of the ISF program. And then when you're released, you will enter and successfully complete the JCDI program. These programs are doing two different things. The first one is to help you make better decisions. It's about thinking and making better decisions. The JCDI program is the drug intervention program to help you with what you need, hopefully, to stop using drugs. So you're going to have all the tools that you need to make these better decisions, and then it's going to be up to you. Continue doing everything you're supposed to through your treatment and other things like that. It sounds like that hasn't been an issue. You're still on a deferred probation. You're still not convicted of this offense. If you're back in here again, in all likelihood, you will be convicted and you will be going to prison for a very long time. Do you understand?
Yes, ma'am.
All right. Good luck to you, sir.
Thank you.
Thank you, Your Honor.
Man, oh man, are drugs hard to kick. I almost felt bad for that guy there because I know he's trying his best, but who knows if he's gonna make it. I hope he does. Let's do one more video. I'm being lazy tonight, but I want to get through at least one more. Not sure who this judge is, not sure where this video come from, so y'all enjoy it.
Good morning. You're Antoine Dill. And Mr. Dill, you were.
No, I've already done that one, so let's find another one. Let's find another one. We'll see about this one.
Court is on the record in State of Ohio versus Franklin Kessler, case number 25 CRA 111.
This is a good one from Ohio. This is a fun judge. I think he gets into this guy pretty good.
Arraigned on 2 counts of abduction, a third-degree felony, and robbery, a third-degree felony. He pled not guilty to those charges on April 29th, 2025. In this case is set for a preliminary hearing today. Court is also taking up City of Conneaut versus Franklin Kessler, case number 25 CRB 81. Defendant pled not guilty to one count of criminal trespass on April 8th, 2025. We conducted a pretrial conference on April 29th, 2025, and this case is set for a second pretrial conference. Court is taking up also companion cases to the felony case 25 CRB 112 and 25 TRD 331, where the defendant pled not guilty to charges of domestic violence, a first-degree misdemeanor, driving under suspension, FRA suspension, an unclassified misdemeanor, and expired plates, a minor misdemeanor. Those cases are set for a first pretrial conference. Mr. Kessler remains incarcerated in the Conneaut City Jail. He's not been able to post the bond that the court set on April 29th. He is appearing by way of video. His attorney, Sean Martin, is in the courtroom. He is appearing at table 2 on the video. Also in the courtroom are Law Director John Lewis, and sitting at table with him, Sergeant Kurt Distel of the Conneaut Police Department. They are appearing at table 1 on the video. And it's my understanding from my bailiff that Mr. Lewis, that this preliminary hearing will go forward?
Yes, sir.
Okay. I'll call your first witness, Mr. Lewis.
Thank you, Your Honor. The serial I will call Marissa Soder.
Okay, so the video is, Mr. Martin, if you don't mind, if Ms. Soder can sit next to you.
Franklin, did you hear what's going to happen?
I just heard that.
So, for the sake of the camera, she's going to sit at the table next to me, but I'm not, just so you're not taken by surprise, okay?
Would you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Okay, you may proceed, Mr. Lewis.
Thank you. Ms. Soder, would you please state your name and spell your name for the record?
Yeah, my name is Marissa Soder, and it's M-E-R-I-S-S-A, and my last name is S-O-E-D-E-R.
Thank you. And are you familiar with the defendant in this matter, Franklin Kessler?
Yes,
And how are you familiar with him?
we were dating.
Sorry?
We were dating.
Okay. Did you live together or anything? Okay.
You'll have to respond verbally, so you can't just shake your head.
For about 3 years.
Okay. I want to draw your attention to April 28th of this year. Did you encounter Mr. Kessler that day?
You'll have to speak loudly. Man.
And please speak, don't just nod your head. You have to say the word yes.
Sorry.
All right, that's okay. Not everybody testifies on a regular basis, so you don't really understand. And so you said you did encounter him on April 28th.
Yes, I did.
Okay. And what, if anything, happened with you and Mr. Kessler on that day, ma'am?
I came home from work. He basically asked me where text messages were between me and one of my friends.
Let me stop you there. When you say you came home, where's your home? Go ahead, sorry.
He asked where the text messages were. I told him that they weren't in there. He got angry. He wanted my phone. I wouldn't give him my phone. I asked my friend to send me the screenshots. He didn't trust that I would show them to him. So he went to go and grab my phone. And when he first tried to grab it, he ripped my shirt. I ran out into the hallway of my apartment building. And as I was going out that door, I don't know if he was going for my phone or for my hair or what, but he had a chunk of my hair, ripped it out, and then took my phone from there. After that...
Let me stop you there. Did he forcefully take the phone away from you?
Yes, I did not give it to him.
Okay. And he also pulled your hair?
Yes.
Okay. What happened next?
After that, he went back into the apartment, said something about somebody's going to be calling the cops now. So I went out to my car, figured this would be my way to get into his mom's house, took him to his mom's. He would not get out of my car when I got there. He said he wasn't going there. So I started walking down the road to get away from him. He started following me. I started running down, I don't know what road it is, it's off of Millard. I started running down that road. He ran right right after me, got up to
Wait a minute,
me.
let me stop you there. You ran down that road?
I walked down Millard and then started.
Why did you walk down the road?
To get away from him,
Okay.
because he wanted to get out of my car.
Did you try to get him out of your car?
Yes.
Try to get him to leave your car?
Yes, I
Did he refuse to leave your car?
Yes.
Did you take him to his mother's voluntarily?
Yes.
Okay. And then you were trying to get away from him and you walked away?
Yes.
Is that correct? Okay. And you walked down the road?
Yes.
What happened next?
He started following me when I was walking down Millard, and then.
On foot?
Yes. And then we got to that road that is off of Millard, whatever that road is right there.
You said he ran after you?
Yes. So he started running after me.
When he ran after you, you saw him running towards you, how did you feel?
I was scared, and I started running.
You started running to get away from him?
Yes.
What? You said you were in fear?
Yes.
Why?
Because we've been in this situation before.
And what do you mean by that? Could you elaborate?
When he got out of prison, he beat me up really bad.
Okay, but so when you say you were in fear of what?
Him.
Doing what to you?
Beating me. And getting me.
Okay, so you were in fear that he was going to assault you. What happens if you did you feel threatened by that when he ran towards you?
Yeah.
Hold on. Mr. Kessler, you can get emotional, but do not say anything, or I'll turn the volume down. You're not going to be heard.
Yes, sir.
Go ahead.
So he ran up to you. You ran from him. Is that correct?
Yeah.
And he caught up to you.
Yes.
Now, what happened then?
Basically, when he caught up to me, I just knew that I had to go back to his mom's house.
You felt that he made you go back to your mom's house?
Yeah.
Okay. Just out of fear?
Yeah.
You were afraid of being assaulted again?
Yes.
And so you went back to his mom's house with him?
Yes.
Okay, what happened? Did you go voluntarily?
Yes and no. I don't know how I would answer that.
Okay. I mean, the question is, why did you go? Why did you not keep walking away?
Because I knew if I kept trying to walk away, he would just keep following me, or it would get worse.
Okay. So you were in fear of him at that point in time? And you went back to his mother's house?
Yes.
What happened then? What happened next?
When we got back to his mom's house, he wanted to go sit on the porch, and I tried to get in my car and leave again. And he got into my car again.
So he wouldn't let you leave?
No. He at some point took my cup and smashed it on the ground in his mom's driveway, and that's when his mom came out. And she started yelling at me, telling me to leave. I told her I would leave if he lets me. He took a water bottle and poured water. He ripped my stereo out, poured water into my stereo to where it just broke so many things in my car. And then his mom, she just kept yelling at me, telling me to leave, telling me to let him leave with me. And she finally said that she was calling the cops. And when she said that she was calling the cops, he finally went back inside, and I drove a few houses down and waited for the cops.
Did you ever get your phone back from him?
No.
The individual that you know as Franklin Kessler, the one who forcibly took your phone from you and restrained your liberty from leaving from his mom's house. Do you see him on the screen there?
Yes.
Okay. Could you describe what he's wearing?
An orange jumpsuit.
Okay.
Record will reflect the witnesses identified the defendant.
I have no further questions at this time, Your Honor. Thank you.
Mr. Martin, any cross-examination?
Yes, Your Honor. Thank you. Good afternoon, ma'am. When you said you went back to Mr. Kessler's mother's house, and I want to make that's what you turned around and went back, right? Okay. You said you were afraid, but he didn't tell you to do that, correct?
No.
He didn't threaten you and say, do this or else.
No.
And you said he wasn't violent to you at that point, correct? I know you mentioned previously there were other things, but that moment when you turned around.
No.
Okay. And you drove a few houses down, correct?
Yes.
Okay. Nothing further, Your Honor. Thank you.
Thank you. Redirect.
Just briefly, Your Honor. Ms. Soder, when Mr. Kessler ran up to you, you ran from him, is that correct?
Yes.
And what made you stop running?
He caught up to me.
Okay. And what, did that put you in fear at that time?
Yes.
What were you afraid of?
Him hitting me.
Okay. And so was it the fear of him hitting you that made you walk back to his mom's house with them?
Yes.
Thank you. Those are all the questions I had, Your Honor. Thank you.
Thank you. Ms. Soder, where did all this take place?
It started at Highland and then ended at his mom's house.
Where's his mom's house? Is all of this in the city of Conneaut, Ashtabula County, Ohio?
Yes.
Any follow-up to my questions, Mr. Lewis?
No, Your Honor.
Any follow-up to my questions, Mr. Martin?
Your Honor, I guess I would just, I would object at this time. I don't know if it's establishing venue would necessarily be on the court's purview to establish those.
I can ask questions, Mr. Martin. Do you have any follow-up questions to my questions?
No, Your Honor, I do not.
Thank you. Okay, you're excused. Ms. Soder, you can go take a seat in the back of the courtroom. Any further questions, any witnesses, Mr. Lewis?
Yeah, Sergeant Distel.
You can stay seated, just so we can get you on camera. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may be seated.
Thank you.
You may proceed.
Thank you, Your Honor. Sergeant, please state your full name for the record.
Curtis Distel.
And would you spell it, please?
Spelling on the last Distel.
Thank you. Are you employed with the Conneaut Police Department?
I am.
And how long have you been so employed?
Over 25 years.
And you're a certified peace officer in the state of Ohio?
I am.
Okay. I want to draw your attention to April 28th. Were you on duty that day?
I was.
And did you have any encounter with Marissa Soder?
Yes, I did.
Okay. Please describe for the court how that came to be.
We were called to the area of Millard Avenue it was reported that Mr. Kessler and Ms. Soder were in the middle of the street, causing a disturbance and blocking cars from proceeding down the road. I responded to the scene, met with Ms. Soder by her vehicle, asked her what occurred, and she described the incident.
Okay. And after you spoke with Ms. Soder, what, if anything else, did you do to investigate the incident?
After speaking with her, I spoke with Franklin Kessler and his mother. We also spoke with a couple other neighbors in the area, asked what they had seen. And
were there other officers there as well?
Yes, Patrolman Ball was with me.
Well, what, if anything else, did your investigation entail?
In speaking with Ms. Soder, she indicated that there was an incident of domestic violence. From what we gathered, it led to the arrest of Franklin Kessler.
So he was arrested that day?
Yeah.
Did you run a leads check on Mr. Kessler at that point in time?
Yes, we did.
And what, if anything, did you learn from that?
It said there was a protection order protecting Marissa Soder from Franklin Kessler.
Okay. What, if anything else, did you learn about that protection order?
The leads printout indicated that it had never been served on Mr. Kessler.
But you did verify that there was a protection order?
Yes, I contacted the sheriff's office and asked if they wanted to send the guy over to serve it, since it hadn't been served yet.
So anything else regarding your investigation on April 28th?
Order had advised that her phone was missing. I had asked to look for it. Ms. Kessler and Franklin gave me permission to search the area around where we had located Franklin, and I couldn't find it.
Anything further as far as your investigation into this matter?
At a later time, I was contacted by the Kesslers, who advised that they later found the phone and said I could come pick it up.
So that would be, when you say the Kesslers, you're referring to the
Yes, I'm sorry.
parents?
Yeah, no, Cody, his brother,
Oh,
and Christina, his mother.
Okay, gotcha. And you indicated that then, what happened after you spoke with those folks?
I went to the scene, met with Cody. He advised that he gave me his word that he would return the phone if he found it. He handed me a phone as described as the missing one by Ms. Silver.
And what if anything did you do with that phone?
Entered it into evidence.
And where was the phone discovered, if you know?
Cody Kessler advised he found it in a sewing machine in the quote kid's bedroom unquote.
And it is the phone that was described to you by Ms. Soder?
It was as she described the day I asked her to describe the missing phone.
Did you do anything else to verify that it was Ms. Kessler's phone?
It had a picture in black and white on the front screensaver that she had described. It was her daughter in a black and white image, and it was a leopard skin pattern on the back of the phone. I also called the number that she had given me earlier, and it rang to that phone. And she also gave me the passcode to unlock it, and I entered that and unlocked it.
And you indicated that Mr. Franklin Kessler was arrested that day, correct?
He was.
Okay. The individual that we're referring to as Franklin Kessler, who was arrested that day, do you see him on the screen there in front of you?
I do.
And could you describe what he's wearing?
Lower right screen, orange jumpsuit.
Record will reflect the witnesses identified the defendant.
Thank you, sir. I have no further questions at this time, Your Honor.
Thank you. Any cross-examination?
No, Your Honor, thank you.
Thank you. You're excused. You can remain seated unless you have to leave, but that's... Okay, any further evidence, Mr. Lewis?
No further evidence, Your Honor.
Okay. So the plaintiff rests? Plaintiff rests?
Yes, sir.
Okay. Defense, any evidence you'd like to offer?
Your Honor, no, not at this time.
Okay. Okay, argument, Mr. Lewis.
Yes, Your Honor, briefly, thank you. The evidence that we've just heard in the courtroom establishes all the elements of both robbery and abduction. The robbery elements would be Mr. Kessler in attempting in committing a theft offense. He stole Marissa Silver's phone, and he did so by force. That is, if that evidence is believed, that is the commission of a robbery offense under 2911.02A3. He pulled her hair, forcefully took the phone out of her hand. She never got it back. Pontiac Police Department did a good investigation and actually came up with the phone and was able to get into evidence. It was taken from his mother's house, Mr. Kessler's mother's house. As far as the abduction, Your Honor, that statute says that no person without privilege to do so shall knowingly do any of the following. Under A2, by force or threat, restrain the liberty of another person under circumstances that create a risk of physical harm to the victim or place the other person in fear. We just heard Ms. Silver's testimony. She felt threatened when Mr. Kessler ran up to her so much that she ran away from him, and he finally caught up to her. She was placed in fear that he was going to beat her as he had done previously, and that she was so frightened that she knew that if she did go back with him, that he might assault her again, and she was placed in fear by that. So she was returned to his mother's house. Also, Your Honor, we heard her testimony that he kept refusing to let her leave, kept refusing to get out of the car to allow her to leave, and that's why she finally got out of her own car and started walking down the road. So, Your Honor, I think that the elements essential to the abduction have also been shown here by preponderance of the evidence, and would ask that this case, both charges be bound over to the Asheville County Grand Jury. Thank you.
Thank you. Mr. Martin.
Thank you, Your Honor. Your Honor, I guess I'll address the robbery first. Your Honor, there's no indication, we would argue that if the court were to believe Ms. Soder's testimony, Sergeant Distel did indicate that he did search the home, did not find the phone. The phone was later returned by another party. Your Honor, at that point, it's my understanding that my client was already in custody at that point. So I don't know what happened with the phone, how the phone got there. I think that's not clear where the phone went, how it ended up in that position. So I don't believe it's proper at this point to attribute that to my client's actions. And then moving on to the abduction count, Your Honor, there were no verbal threats. There was no, while I understand Ms. Soder indicated she alleges violence occurred previous, at this point in time, no violence had occurred. The threat of violence, Your Honor, I believe that's entirely her own subjective belief. I don't know if there's any actual belief at that point that she would be harmed. She voluntarily turned back. She said she voluntarily brought my client to his mother's house. She did indicate that she wanted to leave, but she did not. Your Honor, it's not clear that anything was preventing her from leaving if he got into the car or the things he had done. She did end up walking away, and then later on, eventually, she did end up leaving on her own. There's no indication that my client attempted to stop her, take the keys, obstruct the vehicle from actually moving at all. So with that said, Your Honor, we do not believe that state has met its burden for proving the elements of robbery at this point or abduction to the necessary level of proof. Thank you.
Thank you. Any response, Mr. Wood?
Your Honor, just that the abduction statute talks about by force or threat. Ms. Soder testified that when Franklin Kessler ran up behind her, she felt threatened by his physical presence and the fact that he ran after her down the road. And she testified that she felt that if she did not return to his mother's house with him, that she would be assaulted again. And, you know, I feel that under those circumstances, she was placed in fear by the threat of force, even though it wasn't, stated. She still felt that threat and felt threatened that if she didn't go back, that she would be assaulted again. And so, for those reasons, I feel that the abduction is warranted, should be found over, and the robbery also. It's a tough defense. Took his phone away from her. Took her phone away from her by force. And under those circumstances, Your Honor, and the fact that the phone was eventually found in Mr. Kessler's mother's house, that evidence supports sufficiently on the robbery to also find that over as well. Thank you, Your Honor.
I'm sorry, Your Honor, I was trying to learn myself, but I just had one thing just for the record. I know the state's already spoken again, but I wasn't able to bring something. I couldn't remember the case name at the time, but Counterman v. Colorado, it's a Supreme Court case from 2023. It deals specifically with spoken threats, Your Honor, and that there has to be a knowing and reckless disregard. A substantial risk or statement will be viewed as threatening violence. I know it's not exactly this, Your Honor, but I think that the court could look at the reckless, whether there's a reckless disregard of the conduct that would be considered a threat, and I don't believe that's been met here, so I would just proffer that for the record. Your Honor, my client's raised his hand, and I'm not sure what he's attempting to raise at this second.
Mr. Kessler, you're raising your hand. What would you like?
Can I say something?
Franklin, it's up to you. I would not recommend you speak, though, because it could be used against you.
I would like to say this. I have a broken leg. It's been broken twice. I can't run. There was no way I could run after her down the street. I have a rod that goes from my ankle to my kneecap. I have 2 plates and screws.
Franklin, I can tell the court for you, okay?
Okay, sorry.
That's okay. I appreciate you letting me know. Your Honor, I would just also indicate my client does suffer from a broken leg, and it does hamper his ability to move.
Okay, based on the testimony I mean, we're talking force. We're talking someone Ms. Soder, who testified under oath that he took a chunk of her hair out of her at early on in this entire incident, which is forceful, and that force continued, or threat of force. The court, which court finds that threat of force continued throughout this incident. I do find that probable cause exists and substantial credible evidence has been presented that both offenses charged were committed by this defendant. As a result, I will go ahead and bind this case over to the Ashtabula County Common Pleas Court for further proceedings. That's the felony case. I will also bind over 25 CRB 1112, that being the domestic violence charge, misdemeanor domestic violence charge pursuant to Criminal Rule 5 with the felony case. Unless there's objection. Is there any objections, Mr. Lewis?
No, Your Honor.
Okay. Bond has been previously set in the amount of $50,000, cash surety 10%, with conditions the defendant remain drug and alcohol free, he's subject to random chemical testing, is to have no contact with Marissa Soder. Misdemeanor case, $10,000, cash surety 10%, same conditions. Mr. Martin.
Your Honor, we would ask for a lower bond. I understand the court has concerns, but for my client, these bonds are prohibitively high for him to be able to meet them, for his family to attempt to help them meet him, and I believe that causes an issue under the Eighth Amendment. We ask for a reduction in bonds, just allowing the opportunity to post a bond at this time. Thank you.
Mr. Lewis?
Your Honor, it's the state's position that the bonds as currently set are appropriate and proportionate to the seriousness of these offenses, and also proportionate to Mr. Kessler's substantial criminal history, to protect society from future criminal actions by Mr. Kessler, also to protect Ms. Soder, protect her well-being and her safety from any from Mr. Kessler on the PR1. So we'd ask that the bonds remain the same and not be modified at this time. Thank you, Your Honor.
Thank you. Ms. Soder, there's been testimony that you obtained a civil protection order in common police court against Mr. Kessler.
Yes.
Do you know when that you obtained that?
About a month ago.
Okay. Is it a temporary order? Is there another hearing scheduled?
I have a hearing at the end of this month.
Why would you do this, baby? Why, man?
Would you be quiet, man? Please be quiet, Mr. Kessler, please, or I'll shut you down. Miss.
Shut it down, man.
Okay, you're shut down.
Shut it down. There's nothing else you can do to me, man.
Okay. Ms. Soder, can you tell me what circumstances led to you obtaining the civil protection order? Was it this incident or a previous or another incident?
Back in December, we got into an argument. He tried taking, well, he did. He took my bed and my daughter's bed.
I'm just saying, are they separate circumstances? Get out of the courtroom. You're out. Get the heck out of my courtroom. Get out of the courtroom! Lock that door. Bond will continue as previously set in both cases. Anything further, Mr. Lewis?
Nothing further, thank you.
Mr. Martin?
Nothing for you, thank you.
Okay, this matter is concluded. Thank you.
You know, I would think the guy was a little tougher if he had been willing to do that outburst before he got sentenced, but he waited till after he got sentenced because he's not going to stand on ground. So Larry, what is going on in here? It is time for us to get out of here. It's time for us to go home, go to sleep, do whatever we got to do. But I will leave the live up just for you. So, yep, I'll leave the live up for you. You guys have a great night, and that is going to be it. We don't have the closing credits on this computer, so we're just going to call it quits and have a good night. You guys have a great night, and tomorrow night we've got a special live coming up, so it'll be worth watching, maybe, kind of. We'll see you tomorrow.